you both very much. We're going to go on to City of Miami Beach versus Natalie Nichols.
Well, have a good day. Thank you.
You too. All right, good morning. City of Miami Beach versus Natalie Nichols. Who is the appellant? Mr. Arana, would you like to reserve some time for rebuttal?
Yes, Your Honor. 2 minutes, please.
All right, very well. Go ahead and proceed, please.
May it please the court, Enrique Arana on behalf of the City of Miami Beach. We're asking the court to reverse Judge Hansman's summary judgment ruling, and I wanted to address two critical points with the time I have. First is that controlling Supreme Court decision in Thomas and this court's decision in Brown make clear that Chapter 162 does not preempt the city's fines. And number two, even if there were preemption, the city's fines are clearly severable from the rest of the ordinance. Starting with the preemption point, in Thomas, the Supreme Court...
Hold on 1 second. How would you enforce the ordinance if you are unable to impose the fines?
Well, Your Honor, a couple ways. First of all, the city has a catch-all provision, 30-74 of its code, which applies any time that an ordinance doesn't specify a fine. So if there were no fine here, the catch-all would apply. And in fact, these ordinances, 142-905, when it was first adopted, didn't have a specified fine. And the 142...
Do the fines specified, sorry, Mr. Arana, did the fines specified in 3079 conform with those contained within Chapter 162?
3074, yes, they do, Your Honor. They are the same, and I think you could look at it either way. You either apply the catch-all, which is identical or the same as the 162, or you might say that 162 applies if there's preemption. But of course, in addition to that, the prescriptions themselves are important to the city and are effective, and there are alternative ways, even under the ordinance, to enforce, such as injunctive relief. So the act is complete in and of itself, even without the fines that are being challenged. And I think there's no question that severance would be appropriate.
You're relying on the Thomas case?
Yes. Yes. With respect to the preemption point, we're relying principally on three things. The Thomas case is the only decision we've seen that has directly addressed the issue of fines. And it says in no uncertain terms that the chapter expressly states that its provisions are supplemental and are not designed to prohibit a county or municipality from enforcing its code by other means. Therefore, Chapter 162 does not provide guidance on the appropriate penalties for violation of a municipal ordinance.
But doesn't this case say, counsel, and let's see, I am on page 473, we agree with the Attorney General to the extent that his opinions express the view that municipal ordinance penalties may not exceed state penalties for similar or identical offenses. Doesn't that weigh in favor of your opponent's argument?
I don't think so, Your Honor, because first of all, there are no, first of all, this very decision says that 162 are not binding fines or penalties that are even relevant to the consideration.
Can't you reconcile that language with the language that Judge Lindsay just pointed to by saying you can go beneath the fines that are set forth in Chapter 162, but you cannot go above them? In other words, they constitute a cap, as the trial judge indicated.
I don't believe so, Your Honor. What Thomas says, without question, is that 162 doesn't provide any guidance at all as to what the penalties should be. If they were caps, the court would have said that, and that would have been the holding. The holding would have been you cannot exceed the fines set forth in 162.
But counsel, doesn't Thomas apply to criminal conduct while the caps in 162 apply precisely to Muni Code property violations, which is the subject of your ordinance?
Well, so the issue in Thomas involved a local ordinance that imposed criminal penalties on a traffic infraction involving a bicycle. And what the court said in Thomas is that the city could not criminalize that conduct if it was not criminal under state law. But then it went on to say that the city could impose fines. And then it addressed the question of what would be the appropriate fines. And it says, again, that 162 doesn't provide any guidance on that. The Brown case is to the same effect, and that's from this court. And in Brown, the court expressly held that 162 allows cities to either adopt 162 or completely abolish 162 and adopt an alternative code enforcement system.
Where does it can abolish 162?
That is at page 519 of the opinion. It says 162 confers on local governments the authority to either adopt 162 or completely abolish 162 and adopt an alternative code enforcement system. And that's exactly what.
Oh, I'm sorry. Your opponent argues that the statutory language allows for a differing procedural mechanism for enforcing fines, but the fines are still limited by the express language of Chapter 162. Can you address that concern and address it in light of Stratton versus Sarasota County?
Sure. I would say that the first of all, the language of 162 can't be reconciled with that view because it is incredibly broad and expansive. It says that nothing contained in 162.01 to 162.12 shall prohibit a local government from enforcing its code by any other means. And that's the language that the Supreme Court said means it's entirely optional. And so you can't square it with the language. Second, what this court did in Brown is it upheld Miami-Dade County's alternative enforcement scheme, Chapter 8cc, which provides for an entirely different set of procedures and penalties. And the same is true for Miami-Dade County.
Were the penalties in excess of the caps specified in Chapter 162?
Well, I think in that case, the city of Miami-Dade County imposed a fine that was not allowable under the state code. The Miami-Dade County imposed a fine even after, even if the violation had been cured. But under the state code, a cured violation cannot be fined. So I would submit that under their theory, there would be a conflict between the fines that were allowed. But of course, it didn't make a difference.
Is there a difference here because we're dealing with Miami Beach as opposed to Miami-Dade County?
Not with respect to this. Not with respect to this statute. What this statute does is it provides a mechanism for local governments to enforce their codes if it chooses to adopt it. If it chooses not to, it can enforce its code by any other means, and that's clear from the case law.
Is there a difference between allowing for the creation of a different system of enforcing codes, meaning you don't have to give a notice of opportunity to cure, and a provision which caps the amount that a municipality can impose as a fine under any system? Can you draw
I don't believe
that?
so, Your Honor. I don't think that's consistent with the language of the statute or the case law. I did want to just follow up on the preemption, on the severability point. The law is crystal clear that severance must be allowed if it's possible, and if there's a severance provision that should be honored. Here we have a severance provision, and the statute is complete, effective, even if these fines don't hold up. I don't think there's any basis for invalidating the entire statute when the only issue here was the fines. And I think under the case law that we cite, including case law holding that invalid fines are severed from ordinances all the time. We cite Edwards v. State and other cases. I don't think any real resistance was offered to that, but I wanted to point that out.
You're into your rebuttal time, but I see that Judge Miller has a question.
Sure.
So,
It's a very brief question, Mr. Arana. With regard to the legal authority that you cited on the severability provision, are there any cases that stand for the proposition that you can invalidate all penalties altogether and then leave the remaining prohibition? So I know there's some cases that stand for the proposition that you remove the offending fine that doesn't pass muster. Are there cases within your body of authority that allow for the removal of all penalties and then for the prohibition to stand?
Well, I think Edwards versus State out of the 2nd District, which we cite, involves invalidating the only additional fine, an additional fine that the local government tried to impose in addition to the state penalties, which is, I think, similar to what is being argued here. But I will say again, if these fines were to be invalidated, there are fines that apply under the code, and there are other penalties under the code, including injunctive relief. So it doesn't invalidate all of the fines.
All right, you've used your 10 minutes. I'm going to give you another 2 minutes for rebuttal later. So, Mr. Miller, that means that you have a total of 12 minutes. Go ahead and proceed, please.
Thank you. Sorry, Your Honor. I needed to unmute myself. Good morning. My name is Matt Miller. I represent the plaintiff appellee in this case, Natalie Nichols. I'd like to start by discussing the preemption question, because I think that is what Mr. Rana spent the majority of his time on. Section 1, or Article 1, Section 18 of the Florida Constitution is clear. It says that no administrative agency shall impose any other penalty except as provided by law. So if the city's boards seek to impose a penalty for property code violations, that penalty must be authorized by the Florida legislature. And in Chapter 162, we find authorization for that penalty at subsection .09. And it's a two-part, there are 2 parts to it. The default fines are $250 per day for the first violation or $500 per day for the subsequent violation. Now, Miami Beach has done this. If you have a population of 50,000 or more, you can adopt fines of $1,000 or $5,000. And there are no other alternatives provided in that section. Stratton versus Sarasota County, as Your Honor noted, examined this question at some length and concluded that cities cannot exceed the fines that are found in Section 162. The city is arguing that subsection .03 and subsection .13 provide some kind of an opt-out provision for cities. And that rather than providing for specific fines that a city may adopt, the legislature has essentially told them they can adopt unlimited fines for property code violations. There is no limiting principle.
Mr. Miller, how do you reconcile the argument that was raised by Mr. Arana that Brown stands for the proposition that the municipal agency may increase the fines under the statute? Can you address that briefly?
I can, Your Honor. Brown involved a $250 fine, which did not exceed the statutory cap. The question was whether or not the city had to provide an opportunity to cure. And so it was a procedural case. It did not involve a cap on the fines. The city has pointed. Your
question would be dealt with alternative procedure as opposed to increased fines.
That's correct. And the city has pointed to no case where a Florida court blessed fines that were higher than those provided in the statute. It's pointed to dicta, talking about unlimited authority or how it can opt out. But those cases never dealt with whether or not a court can exceed the fines in the statutory cap. Thomas was very.
I don't want to interrupt your flow, but can you address briefly the arguments that were raised in the brief? And I'm cognizant of the fact that Mr. Arana did not have an opportunity to address it yet. The home rule argument that was raised.
Yes, Your Honor. So the home rule authority allows cities to legislate in areas that the Florida legislature has not expressly preempted. The Miami-Dade Home Rule Charter says that the laws passed by the Florida legislature shall apply to Dade County and to all municipalities therein, and that any provision of any charter of any municipality in Dade County in conflict therewith is invalid. It says in Metro Dade County versus Chase Federal Housing, the Supreme Court said, whenever any doubt exists as to the extent of a power attempted to be exercised, which may affect the operation of a state statute, the doubt is to be resolved against the ordinance and in favor of the statute. We argue that the $20,000 to $100,000 fines that the city is imposing are clearly in conflict with 162.09, and therefore the state statute supersedes any home rule authority that the city may claim in this case.
Is it your position then that 162 preempts the ordinance at issue here?
Yes, it is, Your Honor, because the city has imposed fines that dramatically exceed the caps in 162.09.
Can you address the very broad language that Mr. Arana touched upon that's located within Chapter 162 that may lead a reader to believe that rather than only authorizing a procedural alternative system, it may be substantive in nature? Can you address that, please?
I can, Your Honor. So the city points to .03 and .13. and cases that involve procedures. The language, especially of 162.13, is quite broad. But the Florida Constitution, again, Article 1, Section 18, is very clear that no administrative agency shall impose any other penalty except as provided by law. And so if the city is correct in its interpretation of 0.13, then what the Florida legislature has done is to provide unlimited authority to cities, to allow them to impose $1 million fine or a $10 million fine, or as they've done here, a $100,000 fine for doing nothing more than peaceably renting your home to someone for the night. We submit that the city has pointed to no case that confirms this. No case. Yes.
Mr. Miller, the language in the Brown case is pretty broad. Wouldn't you agree that at the very end, they're holding finding that the county is specifically authorized by Chapter 162 to create its own system and procedure for enforcement, and that the county's alternative system of enforcement is not preempted expressly or impliedly by Chapter 162. Do we need to recede from Brown to rule in your favor, or is there a way to distinguish it? Or are we just bound?
No, I don't think you're bound by Brown, Your Honor. That language does read broadly, but the holding of the case did not the case did not hold that the city can exceed the $250 default statutory cap. So Brown is consistent with Sarasota County despite that broad language, which we believe to ultimately be dicta. The holding in Brown was just that the city didn't have to provide an opportunity to cure. It never said that the city can exceed the statutory caps that have been provided by the legislature. We conducted extensive case research. I'm sure my opponent did too. And Sarasota County, to my knowledge, is the only Florida case to squarely address this question. And the county in that case advanced exactly the same argument that the city does here. They said that 162.03 allows us to opt out from 09. And the court rejected that argument and rejected the city's attempt to collect higher amounts from the property owner than is provided for in the statute.
Mr. Miller, not to shift gears, but can you address the severability arguments that were raised?
Yes, Your Honor, thank you. I appreciate the opportunity to address that. So, as you know, the trial court declined to rewrite the statute. They declined to sever the provisions. That decision is governed by the four-factor cramp test from the Florida Supreme Court. And I won't walk through the factors because I think I would use the balance of my time if I did that. But I would point the court to factor 2, which looks at whether or not the legislative purpose of the valid provisions can be accomplished independently of those that are void. And what I would suggest to the court is that the city has told us precisely what its legislative purpose was in passing this ordinance. They did that in their motion to dismiss. That can be found in the record at their appendix, pages 142 to 143. And there, the city said that the fines, meaning the $20,000 to $100,000 fines, are necessary to deter violations of the ordinance.
Well, Mr. Miller, we don't really need to look beyond the language of the ordinance to make a determination as to what the purpose is, right? The purpose is a prohibition on short-term rentals and to extract a fine for those in violation that will deter, right? So we don't really need to look beyond the language that was employed by the governmental agency.
Well, Your Honor, if that purpose were unknown, I think that might be correct. But the city told us, and in fact, they stood on this argument as a reason why Ms. Nichols' excessive fines claim should be dismissed by the court. So the city went all in on this. They said that the $20,000 to $100,000 fines are necessary, and that without them, people will just continue conducting short.
Let's assume in their motion to dismiss, they said the purpose of imposing this is to create gentrification on Star Island. Would we be looking at their pleading to make that determination in determining whether or not severability is appropriate, or would we be looking at the purpose and intent as expressed in the ordinance?
And I want to make sure that I answer your question, Your Honor. The court can look at anything it wants to determine legislative purpose. And it, particularly when a party expressly says why they did something and they stand on that as a reason to dismiss the case, I think the court should take that seriously. $20,000 to $100,000 fines are, as I think we can all acknowledge, potentially ruinous for most Miami Beach property owners. And the city did that deliberately because they wanted to stop short-term rentals cold. And they said they had to do that because otherwise the short-term rentals would continue. And so without those fines, the purpose of the ordinance cannot be affected. The city, based on what it said itself, will not be able to prevent these short-term rentals. The Florida legislature has now preempted cities from regulating the duration of short-term rentals. It has expressed a policy preference through that law that cities not regulate the duration of short-term rentals. And any argument in favor of preserving one of those legislations should be construed strictly. And in this case, the city simply has not shown that the legislative purpose of the ordinance can be affected if those fines are severed. If there are no further questions, we ask that the court affirm the order of the trial court, and I thank you very much for your time.
Thank you very much, Mr. Miller. Mr. Arana, you may proceed with rebuttal. 2 minutes, please.
Thank you, Your Honor. With respect to severability, first of all, there's no rewriting of the statute required. If the court finds the fines are invalid, it would just eliminate those and we'd be left with the catch-all and 162. Number two, as Your Honor indicated, the purpose of the ordinance is to restrict short-term rentals in certain residential neighborhoods. And the purpose of that statute can be accomplished without the fines. And there is no doctrine that says that severability should be denied because the ordinance would be less effective without the additional fines. Certainly the city's view is that the additional fines are necessary in order to adequately deter, but the prescriptions themselves do that, and so do the fines that would apply. So there is really no basis for saying that the fines, if they're invalid, should not be severed. As far as what the law is on preemption, I think it's crystal clear. Again, council has not addressed Thomas, just like they didn't in their brief. And Brown is directly on point. In Brown, this court upheld the county's alternative code enforcement system. The county adopted an alternative system of enforcement and specifically exempted itself from the provisions of Chapter 162. The court upheld alternative system, and that includes everything. Now, I want to correct one thing that council said about Stratton. Stratton did not address the opt-out. It did not address the 162.13 or 03. So it didn't address the issue before this court, and it didn't involve a fine. It involved the passing through of payroll costs. So we would submit that it's not in conflict. It's not on point. But certainly, even if it was, this court is bound by Thomas and Brown and not the Second Circuit decision. So for those reasons, we'd ask the court to reverse and, if necessary, sever. Thank you.
Thank you so much. Gentlemen, thank you for your argument. Have an excellent day, panelists. I will reach out to you in about 10 minutes on Zoom and by email for our conference. Thank you all.
Thank you.
Court is adjourned.